Okay, so I think we'll get started. Good afternoon, everyone. I'm Diane Hoffman. I'm on the faculty here at University of Maryland Law School, where I direct the Law and Healthcare program. And it's my pleasure to welcome all of you here today for the first Rothenberg Healthcare Law and Policy Speaker lecture of the 2022-23 academic year. Especially want to welcome our distinguished guest, Dean Kimberly Mutcherson. The series, established from funding from the Karen Rothenberg and Jeffrey Seltzer Law and Healthcare Program Endowment, focuses on contemporary issues in healthcare law and policy. And Professor Rothenberg was a former dean here at the law school, as well as founder and director for many years of our law and healthcare program. So it's always wonderful to have her here for these speaker series sessions. In past years, we've done this now during the COVID epidemic, and the themes have included health inequities exacerbated by the COVID-19 pandemic, genetics, and justice in healthcare. This year, the speaker series will have a special focus on reproductive health topics in light of the Supreme Court's June 2022 decision in Dobbs versus Jackson Women's Health Organization. Other speakers in the series will include Elizabeth Sepper, professor of law at University of Texas at Austin School of Law, who will be speaking on religious liberty and reproduction. And then Michelle Oberman from Santa Clara University School of Law, who will discuss doctors' risks, rights, and ethical obligations when providing abortion information. We'll provide more information on those upcoming events at the end of today's session. But our speaker for today, and the reason you're all here, is a preeminent scholar in the areas of reproductive justice, bioethics, and family and health law. Professor Mutcherson is co-dean and professor of law at Rutgers Law School. She has a particular focus on assisted reproduction, abortion, disability, and medical decision-making for pregnant women and children, and her edited volume, Feminist Judgments, Reproductive Justice Rewritten, came out in 2020. Among other honors, Dean Mutcherson has received the Association of American Law School Inaugural Impact Award as co-founder of the Law Dean's Anti-Racist Clearinghouse Project and the Center for Reproductive Rights Innovation and Scholarship Award. She also spoke at our inaugural Charm City Colloquium on regulation of individuals who pursue procreation with the assistance of technology. And you can also find her writing and interviews on these topics everywhere from NPR to the New York Times. Her presentation today is entitled A Phoenix from the Ashes, Reproductive Justice in a World Without Roe. If you have questions, we will ask you to save those until the end of her presentation, and you may include those in the chat function, or you can raise your hand, whatever most convenient for you. So it's now my pleasure to turn over the podium, so to speak, to Dean Mutcherson.
Thank you so much, Diane, for that very lovely introduction and for the invitation to be here with everyone today. I also want to thank Renee Hutchins, who is one of my sister deans, who's amazing, and Rebecca Hall, who has done a really wonderful job of getting me in line to do all the things that I needed to do in order to be here today. And of course, Professor Rothenberg for being the one who initiated this whole series. So my plan today is to talk at you for about 30 minutes and then talk with you for about 30 more minutes. So I'm going to try to get through a bunch of material so that we have plenty to talk about. And in any case, we would definitely have plenty to talk about. I also want to say hi. I see a bunch of people in the audience who I know. Hi, Lizzie and others. Good to see you. So here's what I'm gonna do. One, I want to frame reproductive justice because I think that that is a term that people don't always understand. So I want to make sure that we're on the same page about that. I want to talk about the long road to the end of Roe, but I'm going to do it very quickly. And then I want to talk about a phoenix from the ashes. And I have a question mark there because I'm hoping for the best, but preparing for the worst in this set of circumstances. As I go through my talk, I will use the term women and pregnant women. I'll also use pregnant people or people capable of becoming pregnant, obviously because cis women aren't the only folks who get pregnant. But in my work, and frankly, in a lot of reproductive justice work, it's really crucial to remember that the category of woman matters both historically and in the present moment when we talk about reproductive oppression. So I'm not going to always be using gender neutral language in talking about pregnancy. And I've set my timer for myself. So at some point, if I start talking really fast, it's because I see that my timer is running down, but I'm going to try to really get it into the 30 minutes. So let's start with what is reproductive justice. And one of the reasons why I like to start here is that oftentimes people use the phrase reproductive justice as being synonymous with reproductive rights, and that's just not accurate. So I want to make sure that we understand what I mean by reproductive justice. So the term reproductive justice was actually coined as part of a movement started by Black women in the mid-90s. And these were folks who had been doing amazing work in their communities around a whole host of issues, including reproductive justice related issues. And they were working with a lot of mainstream reproductive rights organizations that were often led by white women, and often white women who had class privilege. And as a consequence, those mainstream organizations tended to be focused on choice and abortion and a lot less aware of or interested in issues that were deeply relevant to Black women. And so the founding mothers of reproductive justice really wanted to build a movement that was focused on issues that were especially relevant to women who were living on the margins and that centered the experiences of those women. So that's what reproductive justice is fundamentally about. And there are three tenets, basic tenets to reproductive justice. The first is that a woman has a human right to decide if and when she'll have a baby and the conditions under which she'll give birth. The second is to decide if she won't have a baby and her options for preventing or ending a pregnancy. And then finally, and this is the one that I think people really need to wrap their heads around, that we have a right to parent the children that we have with the necessary social supports in safe environments and healthy communities, and without fear of violence from individuals or the government. So RJ is human rights based, which obviously makes it very distinct from the way that we talk about reproductive rights in this country, which is very much based on constitutional rights and doesn't really think about positive rights in that context. It is intersectional, and intersectional, again, intersectionality is a word that gets thrown around a lot and that has in some ways lost some of its meaning. So when I use it and when it's used in the context of RJ, it's really building on the work of Kim Crenshaw and the Black feminist thinkers who came before her, where they were rooting the experience of intersectionality in the lives of Black women, for whom sitting at that intersection of being Black and being female meant that our experiences of oppression or discrimination weren't simply about being Black or simply about being a woman, but really came from a specific experience of being a Black woman. And so when I'm talking about intersectionality, that's the way in which I'm using that phrase. And then it is rooted in the experiences of women of color, obviously, as I've said already. And part of that is because oftentimes when we do work and we center the experiences of white women, if we're successful, we protect lots of white women, but a lot of other women get left out of that calculation. Whereas when we focus on marginalized women, that our victories tend to be expansive enough that white women are going to see success from that as well. So affirmative action, I think, is a really wonderful example of that. And then finally, it recognizes that reproductive oppression is experienced differently across communities of color and other marginalized communities. So what should be really obvious already is that reproductive justice is expansive in ways that reproductive rights discourse typically is not. So it encompasses things like environmental justice. So when a majority Black city like Jackson, Mississippi doesn't have clean water, that's a reproductive justice issue. It encompasses criminal justice reform, that reproductive justice can't exist in a country where Black and brown communities continue to be over-policed, over-criminalized, and disproportionately subject to the death penalty and other extreme forms of punishment. And the list of issues goes on, right? Access to universal, affordable health, childcare, high quality public education, inadequate access to healthcare, and disparities in healthcare, income inequality, voter suppression, the overrepresentation of children of color in our child welfare system, homelessness and housing insecurity. So I could go on, but I think you probably get the idea. So what an RJ frame does is it really helps us understand the deep connection between and among various forms of oppression and discrimination and how they feed into each other in really pernicious ways. So I took a long time to lay that out and to do it pretty thoroughly, because if we want to build a world where we have reproductive justice, then we can't just be talking about abortion rights. We have to be thinking and talking about larger systemic issues that impact the choices that people get to make about procreation and parenting. So when I'm having a conversation about abortion, I'm always thinking about it within this larger landscape of reproduction and parenting in the United States, and specifically thinking about the myriad ways in which the law has failed so many of us by placing barriers in front of us based largely on socioeconomic factors like race or income, education level, disability, histories of incarceration, immigration status, and on and on and on. But I'm also really thinking about the spectrum of ways in which the treatment of Black and brown folks in this country across a range of issues impacts now and has in the past impacted our ability to become parents and to parent our children safely. So at a time where there seems to be a bit of a war on history, I think there are lots of parts of our history in this context that are important to remember, and maybe for some people to learn for the first time. So for instance, the history of Native American boarding schools in this country and the idea of civilizing Native communities by taking them away from their families. Eugenic sterilization laws, which covered our country for a very long time, or things like the Chinese Exclusion Act, right, which is a way to try to prevent Chinese men who were here working on railroads and doing other sorts of work from being able to bring Chinese women over to marry and therefore have babies who would be US citizens. So all of this kind of oppression is happening against the backdrop of these really deeply personal choices that people make about whether to become pregnant, whether to stay pregnant when they do become pregnant, and then the decisions that we make about how to take care of our children. And the last point that I want to make here is a point about choice, particularly when we think about the abortion rights movement and the reproductive rights movement and the way in which choice has consistently been used in that context. So the critical point that I want to make here is an obvious one, right? Which is that choice is always exercised within constraints. So if you're having an abortion because your state doesn't have an adequate social safety net, yeah, that's a choice, but not a particularly fair one for someone to have to make. If you carry a pregnancy to term because the Hyde Amendment means that Medicaid won't fund the abortion that you want, that is a choice, but again, not a great choice to have to make. Risking going to prison by sending your child to a public school outside of your official school district is a choice, but one that lots of parents would make if it meant providing an expanded range of educational options for their children. Living in substandard housing because it's the only place you could find where the landlord would accept a Section 8 voucher is a choice, but again, not a very good choice to have to make. So I'm always really suspicious of the rhetoric of choice and how we use it. And of course, along with that, the rhetoric of personal responsibility, because choice is often used as a way to disclaim any responsibility for acting to alleviate somebody else's suffering. And I, for one, don't take pleasure in watching other people hurt. So if there's something that I can do about it, that's something that I want to do. So that's a big umbrella of reproductive justice, which hopefully then gives you insight into what I'm going to talk about next, which is the law and reproductive justice. So I'm not going to give you a whole history of the law of reproduction and parenting in our country, just a little bit of a primer for those of you either who aren't lawyers or whose con law professors only talked about Marbury versus Madison for the entire semester. So there are a series of fundamental rights that the Supreme Court has determined that exist in the context of procreation and parenting. And actually, let me go back because I think maybe that went a little too quickly. Right to the care, custody, and control of your minor children, the right to procreate, the right to access birth control, and of course, what we're going to talk about here today, which is formally the federal right to terminate a pregnancy. So let's start with Roe really quickly. So Roe articulated a fundamental right to abortion decided in 1973. It was a 7-2 decision, so not as sort of controversial even on the court as it has been in the more recent past. So fundamental right to abortion, state has an interest in potential life, but a fetus is not a constitutional person, and then gave us this trimester framework, right? First trimester, states mind your business, it has nothing to do with you. Second trimester, states can regulate, but only to protect the health of the pregnant woman. Third trimester, states can go as far as to ban abortion, but those bans have to include an exception for the life or health of the pregnant woman. And then we got Casey in 1992, which is where that slope really started to go downward. In that case, the court still upheld a constitutional right to end a pregnancy, but then rejected the trimester framework altogether and said, really what we want to focus on here is the viability line. And in part, they said that because they were concerned that Roe didn't give enough weight to the state's interest in potential life. And so Casey was meant to fix that. And so the court there created the undue burden standard. There are a lot of different opinions in Casey. It was a pretty wild decision or set of decisions. But ultimately, they created the undue burden standard, which says that states can't place a substantial obstacle in the path of a pregnant person who is seeking a pre-viability abortion. And importantly, they said that a woman has a right to make the decision, but she doesn't have a right to be insulated during the process of making that decision. So after Casey, we got all kinds of regulation. What states couldn't do, and this was a case that came out of Pennsylvania, what states couldn't do is require women to notify or get consent from their spouses before they had an abortion. But we could create waiting periods. We could create biased informed consent requirements. There could be parental notification for minors as long as there was a judicial bypass option. So I don't want to be a person who seems to be saying, well, we were so lucky when we had Roe and Casey and now everything is devastating, because quite frankly, Roe and Casey were deeply problematic in their own ways. But they did give us some things that were really critical, right? This idea that there's a right to privacy that comes from the federal constitution that protects the right to terminate a pregnancy, the idea that a fetus is not a constitutional person, the idea that states could not ban abortion prior to fetal viability, the idea that there had to be an exception for the life or health of the pregnant person, that you couldn't require spousal notification or consent. And again, that young women could also have access to abortions, and that there had to be a judicial bypass opportunity if they didn't want to talk to their parents or get permission or notify their parents before terminating a pregnancy. June medical services, I'm not really going to talk about, and I want to put it up here really just to make the point that in 2020, the court reinforced the idea that there is a constitutional right to terminate a pregnancy. The only thing that happened between 2020 and 2022 was who was sitting on the court, right? And so there was nothing in the law that shifted. What shifted was the justices who got to make these decisions, and putting aside whatever was said during their confirmation hearings, we are where we are. So from my perspective, and I have very strong opinions about this, and I'm not even going to pretend to be neutral. From my perspective, the 2022 Supreme Court term was basically a disaster, right? On all sorts of different levels. And here we're really just focusing on this particular issue, but the damage that was done was really significant. And the fallout from Dobbs has also been really significant, right? Overruling Roe and Casey completely, deciding that there's no constitutional right to an abortion, and leaving us to sort out whether there are any pieces left to what the Supreme Court had said before, right? So could states now start requiring spousal consent or notification? Is it okay for states to have statutes that don't have exceptions for life and health? Do you still have to have a judicial bypass? All these sorts of things are up in the air at this point. And so the world that we live in now is just absolutely full of chaos. And the people who are paying the highest price for that chaos, unsurprisingly, are the people who are most vulnerable. So in terms of data about abortion patients in the United States, we know that women of color, but Black women in particularly, are disproportionately part of the world of women who terminate their pregnancies. And so when you ban abortion, you're particularly impacting Black women. Low-income women are the bulk of people who have abortions. So when you make abortion illegal, you are very much impacting that category of women. And then, of course, young women. So 60% of abortion patients are in their 20s, and those are the folks who are impacted when they can no longer access abortion. It has been really hard to keep up with the pendulum swings in terms of law in this country, and it will continue to be that way. But I'm going to talk about some of the things that we've already seen. And Guttmacher actually, sorry that the lighting just changed. My lights are motion sensitive. So even though I talk with my hands, it doesn't recognize that I'm actually doing something. So I'm just going to leave it off and not worry about it. So the Guttmacher Institute actually just released some data, since we're 100 days past when Dobbs came down. And part of their data was not only about the number of states who have banned, but the closures that have happened as a consequence of those bans. So 100 days post Roe, they looked at about 15 different states. And in those states, 66 abortion clinics have closed since Roe was overruled. Prior to Dobbs, there were 79 clinics in those states. So 66 of them have been closed. The remaining open clinics in the 15 states that they looked at are only the clinics that are in Georgia. And Georgia, of course, has a very restrictive abortion law on the books right now. They have a six-week ban. And in the remainder of those 15 states, 14 of them have no abortion providers at all. Some of them have clinics that are still providing other kinds of care, but they are not providing abortion care any longer. Of those states that Guttmacher surveyed, there are about 22 million women of reproductive age in those jurisdictions. And of course, those clinic closures are going to have significant impacts on the states where clinics remain open, because now we have these millions of people who are going to look elsewhere for abortion care. And that's assuming that they can even travel. And for those who can't travel, they'll be trying to safely manage their own abortions, or they will end up having babies that they didn't want to have. So one thing that we've obviously seen is a huge reduction in access to abortion care for women and other pregnant people across the country. We've also heard really terrible stories about miscarriage, mismanagement. So where women are being denied access to care that normally would have been provided to them at the point where they are experiencing a miscarriage. We have seen shortages or the denial of access to various types of abortion medications, including those that are used for purposes other than abortion. So for instance, some of these meds are used for treating rheumatoid arthritis, and people aren't able to access them. And we should expect substantially more legislative movement in the realm, particularly of medication abortion, as states try to figure out ways to keep pills from crossing state lines, or keeping their citizens from crossing state lines in order to get abortion care elsewhere. Where abortion is banned, medical schools are trying to figure out what they're going to teach their students and how to teach their students. Medical students are trying to figure out where they're going to learn how to perform abortions, which raises the question, which has been a question for a long time, but becomes even more significant now. Where are we going to get our next generation of abortion providers from? We can expect increased criminalization of pregnant people, and that always ends up targeting, in particular, poor women and women of color. So that is certainly on the horizon, and we've started to see some of those cases start to roll in. This is a pretty short list, and certainly it is growing day by day, and it's going to get longer in the months to come. And then, lest I be too negative, I'll also point out that there are some states, my home state of New Jersey being one of them, that are working very hard to be abortion protective states, not only to protect people who provide abortions, but to protect folks who are seeking abortions as well. So things are bad now. If you are somebody who believes that there should be a right to terminate a pregnancy, things are really bad now. But I want to be really clear that even before Dobbs happened, anti-choice legislators were passing hundreds of restrictive abortion bills around the country. So there were lots of people in this country who already had very limited access to abortion care. So for instance, the Pink House, the Jackson Women's Health, which is the abortion clinic that has since closed in Mississippi, and that was the plaintiff in the Dobbs case, they were the last abortion clinic in Mississippi. And so part of what we're really seeing now is that the circle of folks who are impacted has become much wider. And as a consequence of that, we are seeing people who may have otherwise been able to continue to bury their heads in the sand who are suddenly realizing, wait a minute, this might happen to me. So in a desperate attempt to be optimistic, which is not my nature, I'm trying to really think about what are some of the good things that potentially could come out of this really difficult moment. So I want to talk through some of that before I open the floor to discussion. So remember, reproductive justice is not just about abortion rights. Reproductive justice is about when deciding when and if you'll have a child, deciding if you will not have a child, and the ability to raise your children in safe and healthy environments. And long before Dobbs, again, lots of women and others in our country didn't have access to any or all of these things because our nation, nobody's going to be shocked by this, is riddled with disparities that are rooted in race and in systemic racism. So this is a moment potentially for some interest convergence to happen, right? Where people who thought of themselves as relatively immune from the harms of the various isms that impact our lives are now finding themselves very much in the crosshairs in a way that is obvious, in a way that is really scary to some people, and potentially will move them to seek change. That, of course, only works if people, voters, legislators, are able to see how these choices accrue to their detriment. And that message isn't always easy to get across, as we'll remember from 2016 and afterwards, and the ways in which people vote against their own interests. And of course, the power of empathy hopefully drives a lot of folks to engage in a reproductive justice agenda or to start engaging in a reproductive justice agenda, even if they don't see how it's going to benefit them personally. And finally, even people who are thrilled by this decision, who wanted nothing more than to see Roe overruled, this is a moment for them to really step up, to put their money, their votes, and their political power where their mouths are. So people who proclaim an allegiance to life now have this really important opportunity to show that that is an allegiance that doesn't end in the delivery room. So I can't detail all the ways that I think we should really try to capitalize on this moment, but I want to share a couple that I would describe as being pretty crucial. So the first one is really thinking about and delving into the maternal mortality and infant mortality crisis in this country. No matter what happens in terms of the legality or illegality of abortion, we live in a country where far more women die from maternal morbidity and mortality than should absolutely be the case. We have the highest rate of maternal morbidity and mortality of any developed country. That is a problem, and it has long been a problem for us. And so because of abortion bans, because there are women who will remain pregnant when they didn't want to be pregnant, more women in this country will die in pregnancy, or will die in childbirth, or will die soon after they deliver a child. It is especially true of Black women, who are 2 to 5 times more likely to die as a consequence of pregnancy in this country than are white women. And politicians in these states that are banning abortion really need to have their feet held to the fire on this issue. If you're going to force women to stay pregnant, which you shouldn't do, but if you do, then at least let's try to keep those women and their infants alive. And as this chart shows you, the match between states that have horrific outcomes for new mothers and children and states that ban or severely restrict abortion is, I think, very telling. So let's really call people out on their hypocrisy. This is a moment to do that and vote them out, right? If culture of life doesn't mean we also try to keep pregnant women and pregnant people alive, then it's not much of a culture of life. The other thing that we have, oh, sorry, these are my infant mortality slides. So same issue, right? That what we're concerned about here are the rates at which children of color in particular die very early in life. And these are things that we can do something about if we actually care about it. The next category that I want to talk about is criminalization of pregnancy. Is criminalization of, I'm reusing these slides, and I had voiceovers on them before. I was like, what is happening here? That's why that's happening. So criminalization. One thing that we know is that when we criminalize pregnancy in various ways, whether it's, using illicit drugs during pregnancy, or people who engage in other kinds of behaviors that are thought to injure a fetus, poor women and women of color are the people who bear the brunt of that criminalization. And so as we think about what it's going to look like as states start to target women for self-managed abortions, or even the suspicion of trying to self-manage an abortion, we know who the women are who are going to end up being incarcerated for those choices. And then sterilization. So this is one of those places where the conflict between the experiences of white women and women of color, particularly Black women in this country, is really stark. So on one hand, we've long had this discussion where younger women, particularly younger white women, when they seek sterilization, are told by their physicians, oh, absolutely not, you're going to change your mind, we're not going to do this for you, and all of that good stuff. So on one hand, we want people to be able to access sterilization where that is their choice. On the other hand, we also live in a country that has a very long history of forced or coerced sterilizations for women of color. Black women in the South, in public hospitals, Chicana women out West, Native American women, Puerto Rican women, right? There's the list is far, far too long. So on the other hand, we want to also make sure that people who are not practicing healthcare in the way that we want them to don't use this as a moment to coerce people into sterilizations who otherwise wouldn't want to have them. And then finally, this is also a moment for us to reinforce the idea that words mean things, that science is meaningful, that medicine is meaningful. One of the things that we're seeing already is this attempt to sort of redefine what is an abortion. And expanding the definition of abortion. So for instance, here, Students for Life had a video about how Plan B is basically an abortion, right? So the idea that we can expand the concept of abortions broadly enough to cover anything that might potentially keep a fertilized egg from implanting in the uterus suddenly becomes an abortion. And at that point, birth control is going to be on the chopping block as well. So my last couple of minutes with you, I just want to throw out a lot of thoughts. So first of all, for me, Dobbs matters not because it is this huge watershed in terms of abortion rights, but because it's part of this much larger history of oppression and discrimination in the realm of reproduction and in the realm of parenting. But Dobbs is not an aberration. It's really a validation of what RJ activists have been saying for decades. And so this is really a moment, I think, where righteous indignation that so many of us feel should lead us to remember and act on the words of Audre Lorde, right? I am not free while any woman is unfree, even when her shackles are very different from my own. And as we gear up for the midterms in November, I would really love if I could leave you all today with some very uplifting and hopeful words. But I'm probably not going to do that. What I am going to leave you with, though, is this very urgent sense that we need to act. We are living through extraordinary times that really tragically highlight how ordinary it is for people in this country to be wronged. But we have a chance to act decisively and to demand that this country do better, and not just in the realm of abortion rights. We can demand that majority Black cities like Jackson, as I talked about before, or Flint, Michigan, have clean water. We can demand expansion of the social safety net so that people who choose to parent or who are forced to parent because they can't access abortion services have what they need to raise and care for their children. It's a time for us to continue to challenge the over-criminalization of our country and the over-incarceration that happens in our country, particularly as that system seeks to capture more women who are seeking banned abortions or who are self-managing their abortions. It's a time to demand comprehensive sex education and broad access to contraception, especially for young people. Because honestly, if we wait too long, many more of the protections that some of us have long taken for granted are going to simply slip through our fingers. So I'm pretty tired these days. I'm also really angry. And I believe very deeply in the power of righteous anger. And I believe that those of us who embrace the concept of reproductive justice can't be paralyzed by the enormity of the work that is in front of us, the enormity of work that is required for us to actually achieve reproductive justice, not just abortion rights, but reproductive justice. So in the time that I have with you, I hope that I can urge you to be loud, to be angry, to make demands of yourselves and of the people who make law and policy in this country that impact all of us, although in different ways, and to recognize that being an ally often means using our privilege to amplify the voices of people who are marginalized. And then finally, that this is a year like no other to vote as if your life depended on it, because this year it really just might. So I'm going to stop there and look forward to our conversation.
Wonderful. Thank you so much, Kim. That was a fabulous start to our series. That was just both, well, informative and provocative and inspirational in giving us our marching orders as to what we all need to do. I've asked the audience if they have questions to include them in the chat, and we do have some, I think, already. So we can go to them. I guess it was first, the first question is, well, first, great presentation. And what impact, if any, do you anticipate the Dobbs decision will have on assisted reproduction and surrogacy?
Yay. Thank you for that question. Because this is a huge area that I am thinking about and that I am concerned about. So I think there are multiple ways that it potentially has an impact on assisted reproduction. First of all, to the extent that what we will see and are already starting to see is states expanding what it means for them to have an interest in potential life. We can imagine that there will be more legislation that deals with embryos and how embryos are to be dealt with in particular jurisdictions. So you know, how many embryos can you use in an in vitro cycle? How many embryos can you make? You know, who gets to have access to them? If there is a dispute about embryos, who do they go to and how do we evaluate that? If there is some mistake made, right, so that embryos get destroyed, how do we think about that? Is it a destruction of property? Is it a destruction of life? And what is that going to look like? And that sounds a little alarmist, but just to, you know, give you an example of it, first of all, when George Bush II was in office, he actually had a whole initiative that was about embryo adoption, right? So this idea that if you make embryos and you don't want to use them, or you can't use them, or whatever it is, that you should not be able to, say, give them to research or to have them destroyed, that they should be given to other people so that those people can try to make babies from them. And the way that you might want to think about that is, if somebody truly believes, or if a state starts to believe that an embryo is no different than a 5-week-old is no different than a 5-year-old, well, if you were a parent who abandoned your 5-week-old, we would find other parents, right? So why should we necessarily treat embryos differently? And the second piece that I'll say in that same vein is Arizona already has a law on the books that says if there is a dispute between two people who have created embryos together, that the embryo should go to the person who wants to use them. And if both of them want to use them, the embryos should go to the person who is most likely to be successful in bringing them to fruition. So we've already got states that are thinking along those lines, and more of them will do so going into the future. The second thing that I'll say about this is that Dobbs, as much as Alito and Kavanaugh, tried to take the position of it's just about abortion, nothing else is relevant here, none of the other rights that are our privacy rights are at risk here. If you believe that, then I've got a bridge in Brooklyn that I'd like you to take a look at. There's just no way. And certainly if you read the Thomas opinion, where he at least was honest about saying, if we're knocking down Roe and Casey, we've got a whole bunch of cases that we should be looking at, not the interracial marriage cases, oddly enough, but we should be looking at things like marriage equality. And so, that I think is also going to have an impact on how we think about what it means to have a fundamental right to procreate in this country, and how states might be able to interfere with that in ways that we didn't think were appropriate before.
Thank you. Next, we have a question, several questions from James Evans, who asks, what is the relationship between restrictive abortion law and the quality of public education or access and affordability to daycare? Do the two correlate? And then following up that, he has, how does restrictive abortion laws endanger the rights of women to access care in emergency situations under EMTALA when doctors are scared to provide care when laws are unclear about protections?
Yeah, I mean, so, part of what I said in my talk was, I really do think that this is a moment for a lot of people to put their money where their mouths are, right? And to really say, all right, if I believe that it is important for people who get pregnant to carry through with those pregnancies, then you have obligations that go beyond the pregnancy. That includes things like, why don't we have a better public education system? Why don't people have access to affordable, high quality childcare? Why doesn't everybody have access to that, right? Why aren't we teaching our kids in school about their bodies and about reproductive health, right? I mean, there are all these sorts of things that we could and should be doing in a world in which we actually do value children and we actually do value families. When it comes to EMTALA, so this is one of those interesting places where, and I know, and I've been one of those people who has bashed the Biden administration as well. So I'm not going to, act like I've been a huge cheerleader for them. But at least this is one place where the feds have stepped in and said, listen, EMTALA preempts state laws that ban abortion. So in other words, if you are a pregnant person who shows up at an emergency room and what is needed to stabilize you is an abortion, then even if you're in a state that bans abortion, you should be able to have access to that service because that's what EMTALA requires. The big fight, of course, is what does it mean to stabilize somebody? And in what circumstances is an abortion going to be what stabilizes someone? So I think that there are so many issues that are going to be sorted out over time because there's going to be litigation. We already have tons of litigation. We're going to have new legislation and we're going to have states doing exactly what they did after Casey, which is let's just keep pushing the boundaries, right? Let's figure out if you can have an abortion ban that doesn't have an exception for life so that, a healthcare provider will literally have to sit there and watch a patient die because an abortion can't be provided. Is that going to be okay? Is that going to be constitutional? So there are a lot of things that we haven't sorted out yet, and a lot of issues, particularly issues about the relationship between federal law and state law, that are going to take years, literally years, to sort out. So the idea that what the Supreme Court did here was to sort of, take the federal government out of abortion is just completely laughable.
Our next question, I guess the questioner had to leave, but she asked, what do you think about recent attempts to stop even conversation about abortion and birth control on campuses?
Yeah. So, one thing to remember in the field of abortion, is that restrictions have been in place for a very long time, right? So we've had global gag rules in place. So, if you're receiving money from the United States to provide, reproductive health services, you're not allowed to talk about abortion, or you're not allowed to refer somebody to get an abortion. So this is not new, right? Telling people what you can talk about and what you can't talk about. There is a, really weird sort of fetishization of ignorance that I'm deeply confused by in this country. So again, this is a place where we're going to end up having litigation and discussions about free speech and all of this good stuff, particularly in public school settings. And this is where some of what else is going on in the Supreme Court, I think, intersects really importantly, which is that this is a court that has been very protective of religious freedom, right? And so what does that look like in this particular context? So one of the interesting things that we've seen is the lawsuit from Florida, where we've got people of Jewish faith who are saying, having an abortion is actually something that my faith would require in some circumstances. So I'm really curious to see if that somehow winds its way up to the US Supreme Court, watching this court try to figure out whether it's jurisprudence, which has really been rooted in not just Christianity, but I would say a really sort of fundamental type of Christianity. What is that going to mean when other religious folks are coming forward and saying, well, you need to protect our religious rights too? And that might be our right to talk about or to make sure our kids have education in particular areas, whatever it might look like. So, but that's years down the road.
And thank you for that answer, because that's a nice segue for our, just to re-announce that our next speaker will be Elizabeth Sepper, who will probably be speaking more about that topic of the tension between the freedom of religion and the abortion issue.
Yeah.
So next, Professor Rothenberg, Karen had a question about the future of prenatal genetic testing without access to abortion care. Lots of wide-ranging questions.
Yeah. So this is a place that I think has always been a point of difficulty in the discussion of abortion rights, right? Because there has been this perceived conflict, and I don't actually think it is a conflict, given the people I know who are disability rights activists, but this perceived conflict between people who are living with disabilities and people who are abortion rights activists. I've never met a disability rights activist who is not also pro-choice, but certainly there are people out there. But so I think that this is another place where I worry about what increasing the state's ability to act in the interest of potential life becomes deeply problematic. So, we've already seen states that try to regulate abortion and say, well, you can't have an abortion if it's on the basis of race, or you can't have an abortion if it's on the basis of disability. And there have been, cases that have in the obstetrical field, cases about, wrongful birth or wrongful, I won't say wrongful life, because courts don't like wrongful life cases, but, wrongful birth cases where, the court really used the existence of a right to terminate a pregnancy as a justification, right, for somebody winning a wrongful birth case, right? If you had given me the information that you should have given me, I would have terminated this pregnancy. Well, in a world where you don't have access to terminating a pregnancy, how does that change your relationship with your healthcare provider, right? So what happens when your healthcare provider says, I'm just not, I know what the results of the test are, but I'm not going to tell you because I think you might go have an abortion or try to like travel out of state, and I don't want you to do that. I think most of us would think that's a deeply problematic position for a healthcare provider to take. And yet I worry that that is a position that actually could be protected in the world that we live in now. And certainly a position that the US Supreme Court might be willing to protect.
Great. The next question is from one of our alums, Joanne Hawana. Hi, Joanne. So she raises the question about whether a consequence of the Dobbs decision could be on women's participation in clinical research. For example, if they're in jurisdictions that have enacted fetal personhood laws and an investigational drug or device could potentially harm a fetus, does that kind of issue fall within the broad scope of reproductive justice, or is that a little bit of a different consideration?
No, I think it definitely falls within the scope of reproductive justice. I mean, one thing I will say, though, is that it has been a very long fight to get women appropriate access to clinical research because researchers are so reluctant to have anybody who could become pregnant participating. So, that in some ways is not a new issue. It might become an issue where the state steps in now and says, even if you want to participate as a pregnant person, we're not going to allow you. Or if you're somebody who has the capacity to become pregnant, we're not going to allow you to participate in something that might create risks to a fetus. And once states start doing that kind of thing, the options are really pretty boundless. Right. So, thinking about things like, carving out certain professions and certain types of work environments that people with a capacity of pregnancy shouldn't be able to access, or making it okay to discriminate in some instances against people who are pregnant, who have the capacity for pregnancy, or trying to control the life choices of somebody who is pregnant or who has the capacity for pregnancy. And we've seen that already, right? I mean, we've seen women who, get arrested for some sort of drug crime, and a judge says, if you weren't pregnant, you'd be going home, but you're pregnant. So I'm actually going to leave you in jail for a while because I think you won't be able to access drugs there, and it's better for your fetus. So, these are not things that are unheard of, but they are things that tend to have happened on a smaller scale and to very vulnerable women. So what we might see is a real expansion of the ways in which the state encroaches on the decision-making of pregnant people and people with a capacity for pregnancy as well.
Thank you. Our next question is from my colleague, Matiange Sirleaf. And Matiange, do you want to ask your question? It's a long one.
It is long, sorry. Thank you for this. This has been a fascinating discussion. And so I write in international law. And so I was just thinking about the narrow way in which abortion rights, reproductive justice is sort of dealt with jurisprudentially in the US and situating it in the right to privacy. And I was wondering, I wanted to push a little bit on the what exactly is rising from the ashes, sort of legally speaking, if we could. And so I didn't know whether that meant there might be more creative avenues for trying to situate the right to abortion. So internationally, reproductive rights is implicated in the right to be free from torture, for example, the right to health, obviously the right to privacy, the right to life, the right to education, equality, you mentioned religion. And so I just was just curious, do you think that there's a more generative avenue that might be more emancipatory in terms of dealing with some of the issues you were raising in your talk? Or, I mean, or is just everything lost because of who's on the court and it doesn't really matter? It doesn't really matter what the lines of argument are. But I was just trying to see what you thought, and you can answer both.
Yeah. So one of the other things that I teach is South African constitutional law. And one of the reasons why I love teaching that class is that it forces the students who take the class with me to recognize that a constitutional order doesn't have to look like our constitutional order, and that a constitution can be rooted in human rights instead of being rooted in the negative rights in the way that our constitution is. So yes, I think that there is incredible emancipatory opportunity in this moment, probably not on the federal level, but I think that there are opportunities on a state level to really think about what our state constitutions are doing in ways that we have not been as invested in as we potentially could have been or should have been. So whether that is thinking about obviously right to privacy that is built into some state constitutions, but also state constitutions that have much stronger gender-based protections in them, state constitutions that, if you get into the right state, potentially you could have states that are starting to add to their constitutions more positive rights in this realm, which would be amazing to see that happen. So I don't think, I have no faith in what the Supreme Court is going to look like for a very long time in terms of these issues. And of course, our Supreme Court has never really been interested in human rights or international law. But I do think that we might be in a place where obviously states that are blue and states that are, left, where you might be able to see some really interesting things coming out of the state constitutional order.
And then I guess maybe we have time for one more question. This question is, if a woman dies due to her doctor's hesitation to save her life because they are not sure what is allowed under the confusing laws, can the family sue the doctor or the hospital or the state? Would this type of lawsuit help strike down these laws?
So I'll take the last part of it first, which is no, I don't think it will help strike down these laws. It may create some clarity, frankly, right? In an ideal world, we're not going to use tort suits. I teach torts also, but in an ideal world, we're not going to use tort suits to sort out all of these issues. And yet there is some power in suits like that happening. And unfortunately, I do think that that's where we're going to be headed. And so because healthcare providers don't have sufficient clarity about what they're allowed to do and when they're allowed to do it. And so depending upon when you are, some of them are saying, look, I'm going to provide the level of care that I would have provided before Dobbs, because that's what I do. And that's who I am. And then there are others. If you're working in a hospital system, the lawyers rush down and say, you can't do anything until you can no longer find a fetal heartbeat. That puts you in a really difficult set of circumstances. So I do think that those cases are going to be on the horizon, and not just about what if somebody dies, right? Because even if we end up in a regime where eventually we get to the point where it says you have to have an exception for life, if you don't have a health exception, what about a woman who says, you could have preserved my fertility, but by failure to act quickly enough, I now no longer can have children. That's a significant loss as well. So what does that look like? And would you be able to recover for that? And under what circumstances? So I think, again, I think that the real winners in some sense, if there are any, in what the Supreme Court did, is lawyers, because there are just going to be lawsuits after lawsuits after lawsuits, trying to figure out, okay, what does this world look like now? And it's not going to be enough to just sue in federal court and get up to the Supreme Court, right? It's going to be 50 different states and litigation in all of those states trying to sort out all of these issues. And it's just bonkers. And it's particularly bonkers because while we're sorting all of this out, people are going to be dying. People are going to be losing their kids, right? Because, they're going to get arrested for trying to self-manage an abortion. And then they're going to lose the other kids that they have at home. Most people who have abortions already have kids at home. People are going to lose their jobs because we don't protect people from pregnancy discrimination. There's just There are so many things that are going to go wrong on individual and societal levels that we're going to have to sort out. And it's going to take a long time for us to do that.
Well, Kim, again, thank you so much for this really comprehensive and thoughtful presentation, and for answering so many of the questions that the audience posed. I think we could go on discussing and answering questions for quite a while, but I'm sure you have other things you need to do. But it was a great start to our series, and I hope we will see many of you. Well, first of all, let me applaud and I hope the rest of you will join me in that. But I also hope you will join us for our next lecture in the series, which is Elizabeth Sepper, as I said, on religious liberty and reproduction on Thursday, November 3rd.
And Liz is great, so you should all come, definitely.
Thank you, everyone. And again, thank you, Kim. And
thank you.
We appreciate it so much.
All right.
Take care,
everybody.